Hello and welcome to the first Advocacy by Brodie's recording. I'm Laura McMillan, a solicitor advocate in our Health and Safety and Liability Claims Defence team, and I'm here today with Christine O'Neill, Brodie's chairman, and also a solicitor advocate who's currently first standing junior to the Scottish Government. Hello, Christine.
Morning, Laura.
We're going to talk today about the virtual courtroom, things to do and things to avoid. We'll consider both video and audio hearings, and I'll be asking Christine for some tips on appearing in the virtual courtroom based on her experience so far. So firstly, Christine, can you tell us the types of virtual hearings that are currently being held in the Scottish courts?
Yeah, Laura, and of course, as you know, virtual hearings are not completely new to the Scottish court system. Even prior to the coronavirus restrictions coming into effect, there were some sheriff courts who were running procedural hearings by telephone fairly regularly. Since the lockdown, the use of technology has increased quite significantly. Procedural hearings are regularly held by telephone, and the Court of Session is holding substantive hearings, particularly the Inner House, which is Scotland's civil appeal court, using video conferencing. And last week, the first Court of Session proof, so civil trial, that was scheduled to go ahead with expert and lay witnesses to give evidence remotely was fixed. That case did settle at the 11th hour, which is fairly common, so the proof didn't go ahead, but the court was ready for the proof to be run in that way.
Yeah, I know it's quite a development for the courts. Do you think then, given the changes that we've seen over the last few months, that virtual hearings are here to stay?
I think so, and I hope so. I think so in the medium and the longer term, and I hope so because I think there's really a lot to be said for video and audio hearings, even if they don't work for every kind of hearing. So in the medium term, virtual hearings obviously offer a very effective way of dealing with court business while physical distancing measures remain in place. We know that the Courts and Tribunal Service is starting to reopen court and tribunal buildings, but that's mainly to allow a limited number of court staff and judges access to begin dealing with the backlog of work that's built up during the coronavirus lockdown. And while a number of sheriff courts are conducting limited criminal business in person, it feels like a long way back to anything like the level of face-to-face court hearings that were taking place before March. So I think virtual hearings are definitely here to stay for the foreseeable future. In the longer term, I think as lawyers, judges and clients get more familiar with video and telephone hearings, it seems very likely that they will want to see the savings of time and money that come from virtual hearings become more permanent.
You make a really important point there about the time and the economic benefits for clients here. So if you're right and virtual hearings are likely to be here to stay, it's important, I suppose, for all of us involved to learn to adapt to them. So how have you found them so far?
Well, I've been involved in virtual hearings both as a solicitor, so where I've been instructing counsel to represent our client, and as a solicitor advocate, where I've been making submissions to the court myself. I've not experienced any problems with the technology, whether the hearing's been by telephone or by video, but there's no doubt that the new formats take a bit of getting used to. In my experience, the court clerks and the technicians who are responsible for organising the hearings have put a huge amount of effort into ensuring that when hearings do take place, they run smoothly.
Yeah, I completely agree with that. But it's also encouraged, I think, the parties to work together a bit more as well so that the hearing does run as smoothly as possible. For example, we worked together with the other side in a case to collate a single bundle of papers, which we then provided to the court as well. And that avoided issues like, oh, that's not what's on my page 10, or I don't appear to have that document.
Yeah, I think that's an excellent idea. Taking out as many variables or risks as possible is a very helpful thing to do.
Yeah. So it might make sense to talk a bit about audio and video hearings separately, as from my experience so far, they presented different challenges. Starting with audio hearings, what hurdles do you consider there are for court practitioners?
I think the most obvious challenge for everyone in an audio hearing is not being able to see everyone else in that hearing. The natural rhythm of a hearing, that sense of having a conversation with your opponent and with the court. I think that's just much harder to achieve without the visual cues that you get in a face-to-face hearing. It's very difficult, for example, to read or appreciate the reaction of the judge to the arguments that are being made. And I think for audio hearings, even more than for video hearings, there's a really heavy burden on the judge to choreograph and control the hearing by making clear the order in which everyone is going to be heard and setting the ground rules for the conduct of the hearing.
And do you have any tips for overcoming those difficulties?
I think just pay attention. I think it's really important to pay close attention to what's being said at the beginning of the hearing and as things progress. Important to pause at appropriate points in your submission to allow for questions from the bench, and perhaps to speak at a slower pace than you would normally, which is a piece of advice I'm very bad at following for myself.
Thanks, Christine. Moving on to video hearings, can you tell us about the challenges you think they raise and what you think us court practitioners should or perhaps should not be doing?
In all honesty, I think video hearings are actually a lot more straightforward than audio hearings. They do have that more natural feel to them. And if you can manage to keep one eye on the screen while you're making submissions, it's also a bit easier to spot where a pause is needed, whether that's to allow the judges to find the document that's being talked about, or to allow them to ask questions of you rather than having to butt in the middle of a submission. There are practical challenges. One is that the inner house of the Court of Session is at the moment tending to allow a maximum of 3 hours for the hearing of an appeal, where before that hearing might have been given a whole day or longer. That obviously means that oral arguments need to be more concise, more compressed, or in my case, spoken at even greater pace than usual. To help with that constraint on time, the court is allowing written submissions to be lodged in advance of oral hearings, and it's important to make sure that they're lodged timeously, but that with all the other documents for the hearing, they're in accessible electronic formats. I think it's also worth bearing in mind for those who are appearing in these hearings that media representatives are able to watch the video conference itself, which is relatively unusual. While courts would obviously be open to the press, it was relatively rare for the media to attend many of these hearings. The public are also able to join hearings by audio link rather than directly by video. And that level of access, which is quite proper, does present some challenges for the advocates and the judges who are involved in the hearing, particularly, I think, around privacy. I've been really conscious that video hearings involve a degree of access to participants' homes, which is really quite unique in terms of our previous experience of court hearings. For me, I have tried to make sure that I have as neutral a backdrop as possible to minimise that sense of intrusion and also to avoid distractions. And I think it's worth contemplating those things in advance and taking steps to avoid any distractions when you get started. And then there are the really dull but crucial considerations. Make sure your laptop's fully charged, make sure you can be seen and heard, and make sure you're in a location with the best chance of an unbroken Wi-Fi signal. And finally, if the court offers you the opportunity for a practice in advance, welcome that offer with open arms.
I completely agree. I find the practice session really, really useful. What about the question of communication with clients during a hearing? How do you think that can be done well?
I think it all depends on the technology that you and your clients have available. Brodie's is using Microsoft Teams for most of our online communication with colleagues and clients, and I've certainly used Teams both in audio and in virtual video hearings. We've used the text or the chat function during hearings, which allows clients and indeed solicitors to communicate with the solicitor advocate or counsel. And I've actually, as an advocate, found that more effective than the traditional method of having your gown tugged or hearing a loud whisper or throat clearing from those behind you. And where Teams doesn't work for the client, if it's not available to them, then other options can be used, email or text. although we Brodies are avoiding some other platforms because of concerns we've got about information security.
You've mentioned already that, just to sum up, the first virtual proof was due to go ahead in the court session last week, and it's not going to be the last. So that means hearing evidence remotely from witnesses, including expert witnesses, and different issues will arise from that for court practitioners. But what about the situation for lay witnesses and expert witnesses?
Yeah, that's going to be quite a different experience for both kinds of witnesses, and we're going to do some separate broadcasting with guidance for that in the coming weeks.
Okay, so watch this space. For that, thanks very much, Christine, and thank you for listening to our first Advocacy by Brodies recording.